Hi, welcome back. As I said in the last lecture, I thought I should spend a little more time talking about priorities. One of the difficult parts of your test is going to be looking at a situation and deciding which creditor has priority in a particular situation. And so we're going to go through each of the possibilities in terms of priority and tell you who will win, and you will have to take those rules and apply them to the facts of the problem. Now we know the law permits multiple lenders to take security interest in the same collateral. And lenders want to ensure that their security interests have priority in the event the borrower defaults. If the borrower defaults, the creditor with priority can seize and sell the collateral, and they can satisfy their debt in full before any other creditor. So when there are multiple secured creditors, the money received from the sale of the collateral is not apportioned to them by any sort of means. Instead, the one with priority takes all that is necessary to satisfy its debt. If there's anything left, then that goes to the priority, the secondary priority. If there's anything left after that, it goes to the secured creditor with third priority. So priority is very important in terms of recovering money and making sure that you are in line before other creditors. So in this lecture, we're going to look at the different conflicts between creditors and determine which one has priority. And so by the end of the lecture, you should be able to answer, how do we address conflicts between creditors, and what protections does the law permit buyers of the collateral against those who had security interest in that same collateral. So a conflict between the buyer and the creditor. Now, when two or more parties have security interest in the same collateral, it's necessary to determine who has priority. And as I mentioned in the last lecture, there's a general rule. The general rule is that perfection of the security interest is the most important factor in determining priority. Whichever secured creditor perfects first has priority over any other secured creditor. A perfected security party's interest has priority over a number of other parties. They have priority over an unsecured creditor. They have priority over an unperfected secured creditor, over a lien creditor, and we'll talk more about liens in the next lecture. A trustee in bankruptcy is secondary to a perfected secured party's interest, and buyers who do not purchase in the ordinary course of business. So let's talk about conflicts among creditors. Sometimes conflicts exist among creditors, and it can be very vicious. I've been in multiple lawsuits that involve multiple lenders, all of whom had an interest in a certain piece of property, all of whom who were fighting for priority in seizing that property and selling it to satisfy the debt. When secured creditors are in conflict, the first in time rule usually applies, meaning first in time equals first in right. Let's talk about conflicting perfected security interest. When two or more secured parties have perfected security interest in the same collateral through any of the means of perfection we talked about, the first to perfect has priority. The first to perfect their security interest has priority, even though the other secured party has also taken interest. And in fact, because it's first to perfect, it does not matter which party attached their security agreement first, instead which party perfected first. So a subsequent borrower could still perfect before the a subsequent lender, let's say, could still perfect before the first lender. Though, as we pointed out, a PMSI prevails over a prior perfected non-PMSI in the same collateral. A PMSI, a purchase money security interest, moves that lender to the front of the line, even if there are other perfected interests in that collateral. Perfected versus unperfected security interest. When two or more secured parties have perfected security interest in the same collateral, again, the first to perfect has priority. First in time equals first in right. What about if we have secured interest, none of which are perfected? When two or more secured parties have unperfected security interest in the same collateral, the first to attach has priority. Remember, we talked about the two steps in order to create a valid security interest. The first was the creation of agreement, and the second was attachment to the collateral. In the case that neither party or no party has perfected, we look to see which party security interest attached first. Secured versus unsecured creditor. Secured creditors prevail against unsecured creditors, as well as judgment creditors who have not begun the legal process to collect on their judgment. So secured creditors stand in front of any unsecured creditors, whether they are perfected or not, whether they have priority or not. The secured creditor will stand in front of all unsecured creditors. This is why creditors who loan money without requiring security, the reason why the interest rate is much higher on your credit card than it is on your car loan is that the credit card company is an unsecured creditor. Meaning, if you default and if you fail to pay that which you are owed, they are going to come last. They're going to come behind all of the secured creditors. I have sat through bankruptcy hearings and watched debtors wipe out hundreds of thousands of dollars in credit card debt. Why? Because those credit card companies were unsecured creditors and there were secured creditors in front of them. So again, the way it works is the winner takes all. Whichever party has the priority takes it all, and all that's needed to satisfy their judgment or their debt, and then the rest goes to other secured creditors. So generally in a bankruptcy, there is nothing left for unsecured creditors. And so this is why they charge such a high interest rate, is they must protect themselves against those who will default and leave the credit card company without recourse. A secured party versus a lien holder. We'll talk about liens in the next lecture, but a perfected security interest prevails against a lien holder's claim that arose after perfection. A lien is going to be a right against property, but that right against property is going to be secondary to a perfected security interest. Conflicts can arise between subsequent buyers of the collateral and creditors. And the applicable rule to solve this conflict is going to depend on the status of the buyer. Conflicts can exist between creditors and subsequent buyers of the collateral. Sometimes a buyer will purchase goods that are subject to a security interest. Can the creditor repossess those goods from the buyer? It depends on what is the status of the buyer. A buyer who has the status of a buyer in the ordinary course of business has priority even against a perfected secured creditor. Now, what is a buyer in the ordinary course of business? It is any person who buys goods in good faith and without knowledge that the sale is in violation of a third party's ownership rights or security interest. So this protects you when you go to a store and you buy a large appliance. You buy the refrigerator. The refrigerator may be subject to a security interest, but you are protected because you are acting in good faith. You're buying a refrigerator for your own use. And it has to be in good faith, which again means honesty in fact. And even though you know about the lien, you must be or the pre-existing security interest, you must act without knowledge that the sale would be a violation of someone's ownership right or security interest. So a person who buys goods in good faith for value from a person who is in business of selling goods of that kind will take the goods free of any security interest. Buyer in the ordinary course of business. You go into a shoe store, you buy a pair of sneakers. The sneakers may well be subject to a security interest, maybe several security interests. Nevertheless, you take those shoes home free of any security interest. No one can come and seize that pair of shoes from you. That's yours to keep. That's a buyer in the ordinary course of business. The buyer in the ordinary course of business has priority over a secured creditor even if that security interest is perfected and the buyer knows of its existence. So the buyer in the ordinary course of business has ultimate priority because we are going to recognize that sale of the good to a third-party buyer who is acting in the ordinary course of business will take priority even over a prior perfected security interest. A buyer not in the ordinary course will take the goods free of any unperfected security interest, but subject to any perfected one. Again, this is why perfection is so important. What's a buyer not in the ordinary course of business? If you go into that shoe store we were using as a hypothetical, and you are looking for a pair of shoes, and the owner of the business comes to you and says, I will sell you every pair of shoes in this store, and you can take them and go start selling them yourself. The person who buys those goods, who buys those shoes, is not acting in the ordinary course of the seller's business. The seller sells individual pairs of shoes at a time. The seller doesn't sell its entire inventory of shoes. So in that case, the buyer would not be in the ordinary course of business. Nevertheless, they may still take the goods free of an unperfected security interest, but they will be subject to any perfected one. Remember, when you perfect a security interest, it's as if you are giving notice to the world of your rights to that collateral, and that notice will trump most of those people who are seeking to also take an interest in that collateral. Finally, a second-hand buyer of consumer goods can take those goods from a seller who also held the goods for personal, family, or household use, free of any unfiled security interest. There was a time in which those businesses that sold appliances, they would often loan money to the person to buy the appliance, and in exchange they would take a security interest in the appliance, so in the refrigerator or the washing machine or any of those things. You don't probably remember Sears, but maybe many of your parents would remember Sears. Sears was famous for extending credit for the sale of appliances, which is why so many people bought appliances from Sears. But Sears would also take a security interest in that appliance, which meant that if the borrower did not pay for the refrigerator, Sears or its appointed representative could go repossess the refrigerator or the washing machine or the dryer. Now, if a person bought that appliance for their own personal use and they sell it to, again, a third party, a seller who's that buyer is going to take it free of any unfiled security interest. So secondhand buyer of consumer goods takes the goods free of any prior perfected security interest. So in conclusion, what did we learn in this lecture? Every security interest has a scope of coverage. When two or more parties have security interest in the same collateral, it's necessary to determine which has priority, and the UCC contains those rules of priority. That's it. Again, if any questions, feel free to reach out. I will see you soon.